Okay, thank you, and good afternoon, everyone. For those who don't know who I am, because I may not be your data protection officer, I'm Nick Murphy O'Kane. We provide data protection services as a service to GP practices. Most of you, I think, on here will be part of that group. We're going to look through today on some of the stuff that's going forward. I'm just going to see if I can get this working correctly. Training instructions you've already gone through, so I'll just go over that one again. Our objectives for today, we're going to look at data protection update. It's been just over 2 years now since we've had new data protection legislation in place. There's been some changes, there's been some implications of what's happened, and we'll try and take you through some of those. And we'll do a little bit around data security and protection, especially as a lot of this fits into how about data sharing and information sharing going forward. We have tried to make it up to date as possible. So there is some stuff you may have heard of, you may have seen recently land in your inboxes over the last couple of weeks, which hopefully we can go through. So data protection update. What's happened since 2018? What we're seeing at the moment is the interpretation and implementation of the UK legislation. Since the Act came into force in May 2018 and was slightly changed in January 2021 with us leaving the EU, we've watched very closely to see how data protection legislation is being introduced. There have been some interesting adoptions. There haven't been any new changes since the IP addresses were defined as personal data. But we are still waiting to see how some of these go through high courts before we start getting an understanding of how governments are actually implementing the law. We are seeing key fines on an increase. And this has been quite challenging for a lot of people. We're seeing a number of people thinking they can actually, we call it ambulance chasing, but they'll come to you under data protection laws, and because there's been a breach or there's been something that's happened, they will start to look at see if they can get compensation, because it's a bit easier through the legislation, is what we're finding. There is an increase in frequency, and I think this is one of the things to remind people around. One of the major challenges is where there's breach of confidentiality and duty of candour to tell people about what's going on and what the implications are, and ensuring some things which just cannot be done or is not your responsibility. We've seen an increase in the complaints to the Information Commissioner's Office, the regulatory body. They're increasing not just because of breach of confidentiality. So the common ones we used to see were they've done something with my data, they released my information. We're now seeing a lot more around the process or type 1 penalties, which is I requested subject access request and they haven't provided it. It's been 31 days. So literally as soon as the 30 days, calendar days, month has gone past, they're complaining to the Information Commissioner. And it's important to note that because they don't have to go through your own internal complaints process, they can go straight to the ICO. What we have seen on the responses that have come back from the Information Commissioner is they're not asking us to formally write back to them to confirm what's happened. They're just advising us to work with the applicants more closely and to understand it. So a key message here is if you are doing subject access requests, make sure you know what your timeframes are, and if you're going to go above and beyond the timeframe, excuse me, that you're communicating with the applicants themselves and making sure they're known. We are seeing a number of practices coming to us and expanding on the complexity of some of the requests that are coming through, not just the deceased and letters of powers of attorney, but also with complex cases where we have parent split and areas like that. And people need to be really, really mindful of these ones coming through to ensure that they've got the right pieces in place. And I always advise you, no matter who it is, go to your data protection officer if you're not 100% certain. They will there to advise you. We are seeing checking of compliance by CQC stepping up, and we now know that CQC have actually reported a GP practice up north for not having data protection in place and implemented. Bit of an odd one that came through, but it has been now seen, and CQC are making sure this will include the appointment of appropriate DPOs and publication of this information. So it's really key that you have that done going forward. We are, under the general rule, the Data Protection Act, there isn't much change. We haven't seen the big change that we were expecting regarding the age. So don't forget, a 13-year-old can determine the use of data. But we are expecting to see that's coming through, especially now that we have GP DPR coming through. On the Brexit and EU departure, As you know, until December 2020, we left the EU formally and we came under our own rules. This had an impact on data protection in the fact that we were then not seen as part of the EU and thus not a trusted country. On June 2021, so 3 weeks ago, the EU accepted the UK as a trusted party, and actually now we are back into the old routines. What does this mean for us? It's a return to normality, a return to what we used to know and how we used to do it regarding the processing of personal data within the EU. Some of us may have third-party systems which are holding data in EU countries like Germany or Netherlands, and you need to be careful. I do note that it includes now South Korea. They were accepted the week before the UK. So if you've got any countries that are working in those areas, they're fine as well. If you have anything within your practices where you're not sure, contact your DPO. They'll be able to advise you and look up to make sure you're doing it. What you do need to do is ensure that you're mapping these as part of your register of processing activities, or ROPA. You'll hear this term come up quite a lot in the next couple of months. This is just to ensure that you've identified that there is an overseas transfer and overseas access, and that you are risk assessing that in your DPIAs. The legal basis for use of data. This has been one of the common things that we've seen come up, and people have been asking myself as a DPO around this areas as well. So I want to go through this and touch bases. Was that someone with a question? Cool. There is a legal basis. You have to have an Article 6. It's the common terms we use. So Article 6 for personal data, that's the identifiable bits, and Article 9 for sensitive data. And you need both if you're processing sensitive data. You should make sure that they assure both you as an organisation and any other party that the information that you're sharing, because you are the controller, that they have appropriate bases in place. To give you an understanding of some of this, what we have, so one of the things we're doing is that we have a legal basis for sharing for Discovery Data Service within North East London. You have the legal basis, Article 6, because you're providing services to the patients, and you also have providing healthcare. So that's your Article 6 and 9. The sharing to Discovery Data Service uses similar articles, but they also have research built in there because they're using it for those reasons, and they have service planning built in there as well. So there are other reasons going forward. When considering your legal base for use of data, don't rely on consent. Consent, either direct or indirect, or explicit or non-explicit, should be used as a last resort, and mainly because if there's not another legal basis and you have to use consent, the likelihood is that people may want to change their mind at some point, and it can be a major consideration, especially in areas like research and service planning. Contractual obligations are where you have a contract with a data subject. We see this quite a few times coming through. There's been one recently issued around where we challenged it, where they said, oh, we've got a contract to deliver that. People get confused between a contract between a controller and a processor. These are not legal obligations to use data. The contract obligations are with the subject, data subject themselves. Just to touch base on common law due to confidentiality. This is where common law has defined what's going on, and you have to consider that going forward. There are exceptions, but generally, even with your legal basis, you must demonstrate compliance with common law due to confidentiality. Most of this, in most cases, there will be around things like fair processing and transparency, and I'll talk more about that in a minute. The exceptions to this, in some cases where confidentiality is set aside, with something called a Section 251, which is the NHS Act 2006. And these will set aside where you can actually put it across. The most common one we've used more recently has been COPI, the Control of Patient Information and Regulations.
Data protection पे हो रहा है Zoom का ये, कम से कम login कर लो data protection.
Sorry, say it again.
Data protection का Zoom में हो रहा है training meeting.
कहाँ पर?
तुमको हम दे रहे हैं.
Okay.
If you'd like to come off mute her, she's not asking a question, sorry.
That's fine. It could be interesting, you never know. And by the way, recording of data is quite a sensitive thing going forward. But yeah, the due confidentiality, we have certain exceptions. The most common one we've used more recently has been COPI. And I remind all participants that COPI at this moment in time is scheduled to be stopped on the 31st of September, which means you should now be looking at where you're using COPI. Have you got any exit plans or processes? Excuse me a second. Can you? Sorry about I've talked mainly about transparency, and it's becoming very apparent. You'll see it when we talk about Caldecott principles. It's the new principle, but it's the most common thing going forward. And interestingly enough, I was doing a review of some of the privacy notices that are being published around our GP practices, and there's some gaps in the places. In fact, in some of them is, do you have one that's been published, or where has it been published? It's one of the most important areas because this tells patients what we're using and how we're using their data. But you also need to consider, for those that are practice managers or senior partners, that it's also for staff data as well. And you need to ensure that people are being told how staff data is being used. So the practices should consider on a regular basis, at least twice a year, where is your privacy notice, if you have one, and where has it been published? Most cases, I would expect to find it on a website. But in some cases, we know practices still use manual leaflets and posters in the practice themselves. When was the privacy notice last reviewed and updated? It's been very interesting that some of you still have, especially for those in the Redbridge area, still have Gus listed as your data protection officer on the privacy notice. We've done the best we can with the Information Commissioner's Office, but actually some of these areas are still listing it on their documents, and they need to be updated. And that sort of links into the, does it clearly identify key contacts? Not just your DPO, and you have, for those that use my service, you have the Queries K&G inbox, but also your own practice and where they can contact. We've also had some fun where people are linking to other pages, and you've seen this in North East London quite a lot recently. In many cases, we're asking you just to link to another privacy notice, so the North East London ICS pages. You need to check to make sure those links are still accurate, still working, and that the pages are still relevant. And it would always be good for your practices to check to see what's being published on there. So, for example, in this particular case, most of the data access that's being used for discovery is being published via the North East London ICS websites, and they have the DPIAs and information sharing agreements. So you'll be actually linked into those, and you'll be showing what's going on. Any questions on the data protection update? I was expecting a few more questions, which is the reason why the slides are not as many as we could have put in. Nope. Okay. I will continue. Data security and protection. The DSPT, which most of you now completed for last years, has published its new one, and we want to make sure we understand what's going on, because these do support some of the data sharing principles that we've got. There are a number of new principles. 3 are brand new. These are looking for how you record consent, how you record it in the system to record and manage your ongoing consent. Now, for most of you, that's through your computer systems, but also you need to think about staff consent as well as how you're recording that going forward. Person with IT responsibilities within your practice and also within the CCG where they're providing support will provide appropriate accessible logs to appropriate personnel, and we will do that for you if we're supporting you. The key one for us, and the one that we're raising now, is for you to consider, is the 3rd one, which is organisations maintain a register of medical devices connected to its network. It should include the vendor, maintenance arrangements, and whether network access is given to supplier or maintainer. Think about this within your practice, because while the CCG, as it stands, and going forward the ICS, will have that sort of level for some elements, you may have your own ones within the practices. And what's defined as a medical device actually needs to be considered as well. Some examples that we're seeing where you've got diabetes monitoring systems that are being used, or high blood pressure or AF systems that are going forward as well. Of course, what's now being moved to mandatory is the national data opt-out, and by September this year, you are required to demonstrate compliance with that. I'm working for those practices. I'm DPO. I am working with the CCG to discover what they've done and to ensure that they've got going through. If not, we may have to come back to you very quickly and look at what work needs to be done. But the CCG should be providing that facility, because most of it will be done through discovery rather than through your own practice. EMIS may also provide that if you're using EMIS. This is one key because it is now becoming compulsory, and there's no pushback to move this date any further beyond. Implication of external assurance. We know that compliance with DST is a contractual obligation. It's also part of the key data sharing compliance that you need. And one of those things is to ensure that you maintain it. If, from memory, I don't think we have any practices who have not been compliant. We may have some who haven't published within the area, If you haven't done that, you need to make sure you're informing people what they can and can't do. We continue to see that CQC will check, and they are asking questions and monitoring what's going forward. The same as we now know that the ICO's office are doing the same thing. So it is quite important about the external assurances and going forward. Caldecott principles, I just want to put this in there to remind everybody, because it's been a while since I've spoken to you. Principle 8 was introduced into 2021. This principle informs patients and service users about how their confidential information is used. Range steps to ensure no surprises was what our previous Dame Fiona Caldecott wanted to achieve, and it's ensuring that they're in place. And it goes back to what we talked about with privacy notices. They're not just the notices themselves, but verbal implications as well. And you should consider those going forward, but it is now a Caldecott principle. Opt-out, national and local, and this really, I have a question.
Sorry, Nick.
Oh, that's
Yes,
all right.
a question for you.
Yeah, I'm going to answer that one just after this. I don't
Okay.
because I know what he's asking. PCNs are not legal entities yet. They can't do it. Right, so opt-out, there are two tiers. So we have the national and we have local, but we need to be really careful what people are saying. Members should be aware that there are two very different elements. So we have the legal requirement to restrict processing, and that is part of the data protection legislation going forward. And we have the other requirements. So to clarify, a person can restrict processing if the individual can test the accuracy of the personal data and they're verifying the accuracy of the data. I'm going to come back to this because it's quite important. So if they say that you've got my factual information factually incorrect, so Nick Murphy O'Kane female is factually incorrect. If I say that, then you have a responsibility to restrict the processing of it. And it's quite important you understand this, because you are processing data daily because you're uploading information to other systems going forward. They have the right to restrict processing when the data has been unlawfully processed. And that's where the individual opposes erasure or restriction request instead. They have the right to restrict where you no longer need the personal data, but the individual needs to keep it in order to establish or defend a legal claim. This one is really important for practices because you will hold personal data of patients who are no longer part of your practice, but they've moved on. But you still have some digital materials going forward. So you need to understand that if they say that, you need to restrict that processing. They also have the ability, if the objected to processing under Article 21, and you're considering with legitimate grounds to processing. I will dig out the Article 21. It's one of those I always forget, but this is basically where they're saying they don't want the processing data and it's not necessary. These are very, very limited reasons for restricting processing in law, and that's the legal requirements. So if these are imposed, you must comply. The other types, which are the ones that people get confused with, are in or around what we call national or local requirements. And these are requirements that normally given under common law and key guidance, so such as the NHS Care Records Guarantee. We all know type 1. Type 1 is a opt-out which is primarily used in general practice. It's not used anywhere else, but they are used to prevent the information being provided to any other organisation other than for direct care. They should be applied before the information leaves the practice, and they are still to be there. The guidance that was issued yesterday stipulates that the type 1s, and you'll have seen this in some of the letters that have landed from the Minister for Health, not the Secretary of Health, one of the ministers, which says that type 1s will be extended indefinitely at this moment in time. So they were going to be adopted into the National Data Opt-out Programme, but they're now not. And they will be retrospective as well. So patients don't have to rush to register them. I know we've seen a massive flurry because of the GPDPR has come through. But they are still there and they are still to be done. Key one is that they will be retrospective. So a lot of people thought it's only from that point onwards. If a type 1 is registered, then the historical data will be removed as well, at least from NHS Digital. I'm still waiting to confirm that for Discovery Data Services. The second is the National Data Opt-out. This is one where patients register directly with NHS Digital. They do not register with the practice. Sorry, I should have said type 1s are registered at practice level. National Data Opt-out will hold a register of patients who have expressed a wish not to have their information used for secondary purposes. In those cases, there is a process called a mesh, which will be used to actually apply for that to see which patients they can use. And the principle is simple. I have 100 patients, NHS numbers, I submit that list, NHS Digital check that, and they give me a list back of patients that I can use, 80 or so patients it could be. What that means is that you cannot record national opt-out locally. So just because you know which 20 it was, you can't put that on any system. And it means you can only use the information that you've been told you can use. And it's really clear we need to audit and make sure it's being done as part of the assurance, but also part of ensuring that people trust what we're doing with the system. For other organisations where you're working with, so for NHS trusts, provider services, they will have potentially a local process similar to Type 1, not called Type 1, and you need to be aware of those if you are applying for use for that data or working with those organisations. To answer Arsen's question, yes, you could opt out every patient if you really wanted to, only from Type 1. You couldn't opt them out from national data opt-out because that's a personal request, and then to opt them in. What you will find is that that will have an impact on potential work and research that's being done, potential service planning that's being made, and it may not be in the patient's interests. If you think about areas such as some of the work that Discovery are doing around diabetes and measurements around there, actually some of this information really is essential. I'm not promoting either way, it's the practice decision. We see on average, I think it's about 2% of patients are registering Type 1 opt-outs. That has increased because of the press, but actually they should be discussing with clinicians to understand why and what's being done. It is a benefit to us all within the health and social care sector to have this information there. Ison, let me know if that answers your question, but I'll do the best. And that's really it. I mean, the data sharing elements to it, and I suppose I should have put this in the slide. I will update the slides and just put this in. Just be aware, data sharing groups, you have frameworks in place in North East London. You also have a number of different pieces in or around national data sharing requirements and areas like that. I haven't touched on PCNs and their working arrangements or the federations as well, but I suspect there might be some questions which we can pick up as we go along. So now it's to really, I was expecting questions we went through, so it's a bit short on time, a bit quick. Any questions going forward?
So this is an opportunity for people to ask questions. Please unmute yourself if you find that that works for you. If not, you can put it in the chat box, and Nick would endeavor to answer any of your questions.
I told you this is where we should have kept the cameras on, make sure they're still on.
Okay, if you finish, if the presentation is done, I can stop recording and people can feel free to ask questions. That bit doesn't have to be recorded. So I'll probably stop recording, then people can hopefully will feel more confident to ask questions they might have. Bear with me, please.